Hi, I'm attorney Kelly Longtin, and welcome to our YouTube channel, Kelly Longtin Law, where we discuss estate planning and topics to help you all better understand estate planning, how it works, and how it can benefit your family. So please like and subscribe our page below to learn more about estate planning. Today, I want to talk to all of you about why Snow White's father should have definitely had an estate plan. Now, many of us are familiar with the story of Snow White and the Seven Dwarfs. Central to the story is the relationship between Snow White and her stepmother. After losing his wife, the king decides to marry again to provide a motherly influence for his daughter, Snow White. Now, while things were peaceful for a while, once the king passed away, the queen's true colors came to light. Feeling threatened that Snow White was the fairest of them all, she arranged to have Snow White killed. However, as most of us know, the huntsman showed mercy on Snow White and allowed her to escape. Eventually, after living with the seven dwarfs and meeting Prince Charming, she marries the prince and her stepmother dies. How this occurs really depends on different sources, but although the scenario seems somewhat extreme, this fairy tale shows the conflict that can exist when the unifying member of the family dies without an estate plan. Now, had the king engaged with an estate planning attorney to put his affairs in order, the outcome of this story might have been drastically different. Now, an estate planning attorney would have put everything in writing. While we do not know what the king's wishes were, if he had written them down in a legally enforceable manner, we would know and they could have been enforced. With tangible proof, everyone would have known that what they were entitled to, and it would have been easier for third parties and beneficiaries to enforce what the king wanted. To carry out his wishes, the king had a couple of legal tools he could have utilized. One of those tools is the last will and testament. Now, the king could have used a last will and testament, which is a document that names a personal representative, also called an executor, to collect all of the king's accounts and property, pay his outstanding debts, and distribute his money and property. A will would specify who would receive the king's accounts and property and name a guardian for Snow White, as she was a minor at the time of his death. Although this document would be legally enforceable at the king's death, it could provide an official way to express his wishes. One downside of relying on a will, however, is that to distribute the king's money and property, his loved ones would have been required to go through the probate process. And that's a court supervised procedure to distribute accounts and property to loved ones upon a person's death. Alternatively, the king could have created a revocable living trust during his lifetime. The king would have been able to change the trust document at any time until he became unable to handle his own affairs or if he passed away. This planning tool would have allowed him to name himself as the current trustee, the person or entity who manages and invests and distributes the money and property, and to designate a trustee or backup trustee if he was unable to act. During the king's lifetime, he would have had to either change the ownership of his accounts and property, his assets, from himself to an individual, to himself as the trustee of the trust, or designate the trust as the beneficiary of his assets. The trust would have allowed him to continue enjoying his assets during his lifetime and designate who would inherit from him upon his death without probate court involvement. This would protect the inheritances of his loved ones and keep prying eyes out of his affairs. Now, if the king executed a revocable living trust as part of his estate plan, he would also have a will, but it would be called a pour-over will. This document would be referred to if one or more of the king's assets were not properly transferred to his trust during his lifetime or at his death by beneficiary designation, or if a guardian needed to be appointed for Snow White. The difference between a will and a pour-over will is that a pour-over directs that all assets subject to the probate proceeding be transferred to the trust instead of a person. Although the king's loved ones would still have to go through probate, The probate assets would end up in the trust, managed and distributed according to his trust instructions. His estate plan also would have appointed someone to be in charge. Once the king passed away, the law would dictate who could step in to handle his affairs if he did not have a legally valid estate plan. The stepmother might be at the top of the list as a surviving spouse. Because she was older than Snow White, she might have had more leverage to step in and take control. By creating an estate plan, the king would have appointed and empowered a trusted person as the personal representative under his last will and testament, or as a successor trustee under the trust to handle the affairs, such as a trusted friend, advisor, or neutral third party. He could also have an estate plan that would have protected the inheritances. Given Snow White's young age when her father passed, it is likely that she was too young to manage a large sum of money or rule a kingdom without some guidance and oversight. Therefore, whatever he wanted to leave behind for Snow White could have been held in trust for her, either under his will as a testamentary trust or as a subtrust of his revocable living trust. A trust would have allowed him to craft specific instructions on when and how Snow White would receive her inheritance. If the king created a separate subtrust for Snow White, he could provide instructions so Snow White would receive her inheritance when the king died, instead of waiting for her stepmother to pass away to receive whatever was left over. Holding an inheritance in trust is not just for minors. The king could have also placed whatever inheritance he wanted to leave to his wife in trust. He could have provided specific instructions about how much she would get and when she would get it, so that he would have that assurance that she was provided for. He would also have been able to dictate who would receive the money or property left in the stepmother's subtrust when she died. In this case, he could have named Snow White as the next in line to receive whatever was left in the stepmother's trust. Another thing to think about is Snow White could have had a much better guardian. Upon the king's passing, a decision had to be made about who would look after Snow White. In this instance, it appears as though her stepmother was in control and did not make for a kind or caring guardian. However, had the king truly thought about this, he could have nominated someone else. Now, perhaps there was a grandparent or an aunt or an uncle who would have been able to step in, instead of the dwarfs who ultimately took care of her. A guardian's nomination is usually included in a last will and testament or a pour-over will. While this is just a nomination made by the deceased parent, it can carry significant weight when a judge is looking to appoint a suitable guardian. Some jurisdictions have a separate document that a person can use to nominate a guardian. This document would be referenced in the will or pour-over will as well, but would be the only document needing revision if the king changed his mind about who he wanted to raise Snow White. You can do your part to help ensure that a fairy tale ending happens for your loved ones. While the story of Snow White is just a fairy tale, important lessons can be learned from it. We all want our loved ones to have happy endings. We can help you take the steps to avoid those types of bad outcomes that are part of the typical fairy tale. So if you need to review your estate plan or put your estate plan in place, please reach out to a local qualified estate planning attorney in the state in which you live. If you currently live in Massachusetts or New Hampshire, please reach out to us at kellylongtinlaw.com and we'll be happy to assist you in your estate planning needs. I want to thank you for watching. I'm attorney Kelly Longtin from Kelly Longtin Law.